Yeah, the whole qualifications issue is very confusing and really kind of a morass for the field of mediation, and probably an unsolvable set of issues just because mediation's everywhere. And what can we say about qualifications for a mediator that's true, whether you're doing a juvenile offender mediation or land use or divorce or public policy? And because mediation's everywhere, it's kind of hard to regulate in a meaningful way. And so you end up with often a reality of the balkanization of the field, that different substantive areas have said what makes sense for us. And it's unfortunate that we spend a lot of time trying to regulate and identify across the board qualifications without success, and we've ended up where we have. Well, a part of that in many areas is a 30 or 40 hour basic training, and I think the concept there is, whether you're an agency or a court or some other regulating body, that you want to ask people to do something meaningful. We also tend to regulate mediation to the extent we do it in really a minimalistic way, that you must have done these minimum things without often much higher aspirational goals. Some states, for example, will require continuing education, but not all, and even if they require it, it's uncertain as to whether they track it. So it's a real challenge, because the barriers to entry for mediators are remarkably low, typically 30 or 40 hours, maybe a handful of cases. And because the barriers to entry are low, you have a lot of people wanting to take advantage of that opportunity, but they don't necessarily have the ongoing commitment to continue that education, and they may not get a whole lot of experience either. So we have a challenge here. What I think will happen over time is that the regulation in a balkanized way will deepen and grow. I'll give you an example. In Singapore, where they're now very serious about regulating mediators, they don't talk about a 30 or a 40 hour training. They talk about a 9-month training period, during which there's a variety of trainings and video feedback and all kinds of other supervision and experiences. We started out thinking that all mediation was the same, but for purposes of regulation and growth, I actually think it is going to break into a different number of sectors that over time will likely deepen the requirements they have for their type of mediation. The training I do is primarily focused on assisting participants to be at their best in mediation, to do whatever they can amongst themselves, and then to the extent the mediator needs to help out, for the mediator to in fact do that in a way that creates as much substantive satisfaction overall as possible. So I call that maximizing mediation, the way I approach it. Again, I want the individual to be supported in being at their best. I want to support the group in doing anything they can do amongst themselves. And yet I'm also willing to get in there on all fours and help them come up with maximizing solutions, as opposed to being kind of an above the fray referee. And I'll again say that I think it is mediation's ability to support most capable solutions rather than just any old solution that will distinguish it in the marketplace. Let's talk about online dispute resolution. The big mistake many people made in thinking about online dispute resolution initially was to think that it was something very different from face-to-face. So we had online and face-to-face. Well, the critical first piece is to appreciate that even most face-to-face mediators who don't think they're mediating online are. They're already mediating online. They're using email, they have websites, they're sending attachments, they might be using track changes with Word, they're using Skype for purposes of talking to people and seeing them. And so the big mistake is to think either or. And in fact, for most mediators, the first challenge is, how can I best integrate online technologies to enhance my face-to-face services? But you've got to take this attitude of integrating what's there. Quick examples of, if I'm mediating a divorce in Oregon, overnight, the Oregon Child Support Guidelines are online, and I would be committing malpractice to not advise my clients, here's where the guidelines are, here's where the calculator is, you can plug your own numbers in, have fun, take a look, let's meet up, and talk about these things next time. So overnight, as the state puts certain resources online, reasonable practice requires that you practice online. Similarly, there's now a parenting plan center online that any reasonable mediator would advise their parties and work with them online. So for purposes of offering even reasonably capable services now, the face-to-face mediator doesn't have an option but to capably use the online. And we already are, just because it's so commonsensical, we don't even think about it. We all send email, even though it's not very secure, for example, because it's so darn efficient and affordable and effective that we just do it. And the clients are appreciative, and they enjoy it as well. Now, you do get to an interesting area when you ask yourself about exclusively online. Can we actually mediate things where geography is irrelevant, where the people don't have to be in the same physical place? And I do think that there are these opportunities. We already know there are. For example, all the domain name disputes have been resolved online. We know that eBay has the biggest dispute resolution system in the world, and they resolve at least 85% of their disputes exclusively online. In more practical areas, to give an illustration, it may depend on the scope of the dispute and how complex the issues are. For example, I'm finding that it's much easier for me to mediate a child support modification or a parenting plan modification online, where the divorce is done and we're now downstream, and there isn't as much drama, and the issues are much more limited, as well as the variability. And in this context, folks will be motivated to resolve the matter by phone, online, just in some way that doesn't force them to incur $2,000 or $3,000 or $4,000 of travel and transaction costs, because that's more than they're even talking about, in terms of the adjustment. So what I'm finding is that as the online becomes ever more real and ever more capable, as the costs of physically getting together become greater as well, that in certain situations there are disputes where there's enough at issue to care about, but not so much to wage World War III over, or even to necessarily get on an airplane for. And for these types of disputes, child support modification, parenting modification, other examples might be Americans with Disabilities Act. I mean, these are folks who almost by definition have a difficult time in many situations getting to a physical forum. And so now we have the opportunity, or in special ed, to bring services right into the home where no services have previously been able to be accessed. And in some of these cases, you can actually have the disabled community be part of the mediation services. So we say when you're on the internet, nobody knows you're a dog. When you're on the internet, people may not know that you're blind, or that you have different abilities, or the like. So we are just scratching the surface in terms of professional services being available online. It will be much more like in your living room is how we'll start thinking of them. And this is happening faster than we can even take in right now. Does it need to be exclusively online? In some cases, yes, but in many cases, no. In many cases, it may be that we get together once or twice physically instead of 3 or 5 times, that we use both the face-to-face and the online.